Hello everyone, this is Tom Fox and I'd like to welcome you to episode 226 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things FCPA compliance related. In today's episode, I take a look at the top 5 compliance-related events in 2015. In my last episode, I looked at FCPA enforcement actions, and I really limited myself to that. In this episode, I want to expand out into the broader world and talk about the things that I think were the most significant over the past year. So with that, I'd also like to remind you that I have an upcoming FCPA Masterclass in Houston, Texas on January 21 and 22. I still have a couple of slots open. This is the best nuts and bolts Masterclass regarding FCPA compliance programs. You will learn how to design, implement, and enhance a best practices compliance solution. I only take 10 attendees, so it will be a true learning experience. Lots of detail, lots of information. I hope you can join us. If you need more information, check out my website, Advanced Compliance Solutions, or you can contact me directly at tfox@tfoxlaw.com. Thank you very much. Hello everyone, this is Tom Fox again. So we had quite a significant year in compliance-related events, and I think probably the thing that started it off to be the year that it was the FIFA corruption scandal. In May, led by the U.S. Department of Justice, there were arrests of 14 FIFA officials, largely in Switzerland. It was a coordinated effort between many countries, but particularly the Swiss. These people were, FIFA officials were arrested where they were there for a meeting. They were arrested at luxury hotels. They were largely, although there were 3 U.S. citizens, they were largely FIFA officials from the Americas, CONCACAF, COMCOL, and they have been some successfully extradited, some have voluntarily agreed to come to the United States, and some are still fighting extradition. This was really a significant event because obviously soccer, or what the rest of the world would call football, is the world's biggest sporting event, biggest sports rather, and then the World Cup certainly rivals the Olympics. World Cup lasts a little bit longer with less people involved in the Olympics. Nevertheless, the monies generated are just astronomical. $5 billion, nearly $5 billion in revenue for the last 2014 World Cup in Brazil. The indices and information around FIFA, I think it's really not any surprise, and most people have known for quite some time that FIFA was about as bent as one organization could be. They have put the pretense and fraud on of trying to reform, or allegedly saying they were going to reform themselves for some time, and they never did. The monies that were paid out to these officials for both as bribes, alleged bribes to get votes for holding World Cups, for marketing agreements, for television rights, just astronomical. There was one U.S. company which was identified but not named in the original indictment. There was in early, I think November, perhaps early December, a superseding indictment where additional FIFA officials were named and arrested. So very, very interesting. First and foremost, this was not an FCPA case. FIFA is not subject to the Foreign Corrupt Practices Act. This was a RICO case. And for those of you who don't know, RICO is Racketeer Influenced Corruption Organization. It's basically, if you're a criminal organization, you can be held liable for the actions of anyone involved in your criminal schemes. And RICO held that the way FIFA was run, it was essentially a criminal organization. FIFA has been able to maintain victim status in this, which means that they've been able to exist, continue to exist. They've had several notable suspensions. Sepp Blatter, Michael Platini, and others were suspended. As of the recording of this podcast, Sepp Blatter is still the president, although he was suspended. And there is an election in February for a new president of FIFA. Whether FIFA can ever clean itself up is obviously an open question. The entrenched parties, the entrenched corruption, the entrenched nature of the organization, it's going to be not clear whether it can survive or can reform itself. So that's still an open question that we will probably be exploring on our 2016 wrap-up podcast in early 2017. So FIFA really started off the year from an international perspective with a bang. Continuing from 2014, we had the ongoing Petrobras scandal. And one can only say that it got bigger, badder, and much worse for the Brazilian government. The president of Brazil has not been directly implicated, but she was the head of Petrobras when many of the events took place. The first round of prosecutions for Yavolita, which is car wash in Portuguese, which is how all this started, amazingly enough. The first round of arrests dealt with Petrobras senior officials who were just basically taking 3 to 5% off of every contract. So they were making millions that were being diverted to Switzerland and diverted away from Petrobras. But the corruption scandal has expanded almost exponentially to major banks in Brazil, major construction companies in Brazil. A large number of Brazilian elite have come under scrutiny. And of course, Petrobras operates in the United States, so it's certainly subject to U.S. jurisdiction for the FCPA purposes. And many U.S. energy companies who have done business with Petrobras are now either under scrutiny or taking a very hard look at their operations. Just this week of the recording of this podcast, a Houston-based company, Ensco, was alleged to have paid a bribe to Petrobras officials for a contract. The Ensco has denied all of these allegations, but nevertheless, Brazil has severed its relationship with Ensco because of this. Additionally, there was a purchase of a chemical refinery in Houston, which has drawn scrutiny. And in this, Petrobras officials bought a refinery for over $1 billion, which some 12 to 18 months previously had been bought for $300 million. So certainly questions about the purchase price and what happened to the money of this purchase. It's still kind of up in the air. So the Petrobras scandal has moved into a worldwide phase. Rolls-Royce, SLB in Belgium, other countries, or SBM rather, in Belgium have also come under scrutiny. Shipyards in Singapore have come under scrutiny. So this one could have been, or could be, the one of the biggest energy-related corruption scandals around. That brings us, of course, to Volkswagen. And this is not an anti-bribery or anti-corruption scandal, but an emissions testing scandal. And this was a almost decade-long fraud that Volkswagen perpetrated upon U.S. regulators and other regulators across the globe regarding their diesel engines and emissions testing. Volkswagen had installed something called a defeat device, which prevented accurate readings of its emissions when it was being tested as opposed to in operation. Excuse me. Very bad facts. Volkswagen basically admitted it when confronted by U.S. regulators. This case will probably be studied from the PR perspective forever because of the missteps Volkswagen engaged in, which included not getting out ahead of the scandal. And when U.S. regulators confronted the company and the company admitted it, the company still didn't make it public announcement. And I remember because it was on a Friday and the EPA released the allegations, and so I waited over the weekend to see how Volkswagen would respond. And basically the next response on Monday was, oh yeah, it's true. That is not the way to get out ahead of a scandal. In addition to that PR disaster, members of the Volkswagen board were not even told about these allegations. And several board members were quoted. They found out about it in the newspaper or on television. So stay tuned to CNN, I guess, is the message if you are a Volkswagen board member, because more bad news may be coming. Certainly very bad. Volkswagen's conduct with U.S. and European regulators has been called into question. As of the recording of this podcast, Volkswagen has not cooperated fully with U.S. regulators and U.S. states attorneys general who are involved in civil lawsuits against the company. They are claiming or standing behind or hiding behind, depending on your perspective, German privacy laws. The EPA, through the Department of Justice, has filed civil suit against Volkswagen, claiming damages under the Environmental Protection Act of up to $18.5 billion. The Yates memo, which we'll talk about in a moment, certainly ties into the Volkswagen case because it's going to be the first real test to see if the Department of Justice is really serious about going after individuals. However, I would caution, and we'll go into this in some detail in the Yates memo, the thrust of the Yates memo requires that companies turn over individuals if they want cooperation credit. So query, does Volkswagen want any cooperation credit? Perhaps they don't. Perhaps they're just going to say, we're going to protect our people, you can't extradite them, and you can't get them. So if Volkswagen does make that scorched earth decision, and I don't know who has counseled them on it, but I would certainly suggest they may want other counsel, it's going to be very, very important that there be cooperation if Volkswagen wants to settle. But if not, they want to hide behind those laws, they certainly can stand on that and suffer the consequences. What that means for Volkswagen going forward in sales in the United States or sales on a worldwide basis, at this point, who knows? But it's certainly very, very bad for Volkswagen. The other thing that I think why the Volkswagen scandal is so significant is that it's really moved compliance to the forefront as the only part of an organization in which it can protect you. Volkswagen was the first scandal I can recall which damaged a national brand. The national brand of Germany was viewed as quality and honesty. And when you damage a national brand, you have a national response in the form of very aggressive prosecution or more laws. So that's really up to the German government. But the Volkswagen scandal also damaged the reputations of their competitors. So Mercedes-Benz, so Opel, so BMW, all were dragged into this. And this is the first time I can remember competitors suffering for the sins of yet another competitor. Well, the reason this is so significant for compliance is the only, and I mean only, response available to you is a robust compliance program, a transparent compliance program, a program that if a competitor gets in such trouble, a regulator comes to you and says, show us your records of your emissions testing. You have those records. They are documented, and can be turned over. They can be turned over to your board. They can be turned over to your internal investigators. They can be turned over to shareholders and stockholders. And if need be, they can be turned over to the press. So I was very, very pleased when the president of the German Global Industry Association was quoted in the Financial Times, and he urged German companies to check their management processes, including compliance and control systems. He said, the question you need to ask is, are we doing everything right? Well, that's precisely what a compliance officer does. A compliance officer differs from a general counsel. A general counsel wants to know, are we doing everything legally? Well, that's very different from, are we doing everything right? The general counsel wants to know and will report the truth. The chief compliance officer wants to report the entire story. So I think this will lead to even more importance of compliance, elevation of compliance within an organization, because compliance is the only function in a company which would have a broad enough reach to be able to give a CEO or a board a solid answer on, are we doing everything right? Next up is the first British Deferred Prosecution Agreement. This involved a UK bank, ICBC Standard Bank, which engaged in a subsidiary, engaged in bribery and corruption in Tanzania. Yet the parent organization was able to get a deferred prosecution agreement because of their best practices compliance program and self-disclosure to the SFO, or the Serious Fraud Office. The SFO director, David Green, called this a landmark DPA, which would serve as a template for future agreements. The judge involved also lauded both parties, and was quoted as saying, "I applaud Standard Bank for its frankness with the SFO and their prompt and early engagement with the SFO and the court." So there was significant judicial participation in this process, very unlike the United States. Yet I think the U.S. might draw inspiration from this, and the Department of Justice would consider the positive effects of court oversight over DPAs. It might take away some of the criticism that has been leveled on DPAs. Certainly this DPA in the United Kingdom was drafted by the SFO, the prosecution, the defendants, and the court was involved as well. So when you have all of those parties, you have multiple viewpoints, but you have transparency. And I think that that may be one thing that is criticized about DPAs the most, is lack of transparency. So very significant first DPA. David Green has assured us that more are coming. He has also made clear that if you do not self-disclose, you will not get a deferred prosecution agreement from the Serious Fraud Office. Hopefully this will end the nonsense or nonsensical commentary from certain UK politicians to end the SFO and fold it into other prosecutorial organizations. The SFO clearly has an important role. Enforcement of the UK Bribery Act is very important and very significant for the global fight against corruption going forward. So I've saved for the end something we touched on in the last podcast, which is the Yates Memo and the Compliance Council. I don't think you can emphasize the Yates Memo enough in terms of the focus, the change in focus it's going to bring to corporate investigations. The Department of Justice has always prosecuted individuals under the appropriate facts. But here and now, if a company wants any, and let me underscore that with double underline bold, any cooperation credit, they have to pony up corporate employees who have engaged in bribery and corruption. The higher, the better. That's to even move to a question of whether you have any sort of best practices compliance program, which would reduce your overall liability, perhaps garner you a declination, but certainly a DPA or NPA. So corporations, frankly, are not set up to do government investigations. They're set up to do internal investigations, root cause analysis, figure out why something happened so that it doesn't happen again. How did it happen? But now, before you even get to that, you've got to turn over individuals. What that may mean for senior management, what that may mean if for board of directors, it's unknown at this point. The department has incentivized prosecutors to move forward against individuals, and it's really penalized them if they don't. They have to write significant memorandum of why they're not going after individuals. So I think the Yates Memo is a significant turning point. It's not been put into practice that we know of as yet. I think the Volkswagen case may be interesting, but as I indicated, perhaps Volkswagen they don't care about cooperation credit. They're not going to cooperate. I think that's a stupid thing on their part, stupid move. I certainly hope that a lawyer didn't counsel them to do that. Nevertheless, it's certainly possible. Finally, the Department of Justice Compliance Council and the metrics we went over in some detail. I think this is going to make compliance even more important going forward. It's going to be more important because your compliance program will be graded basically by someone who has been in the industry and knows what's an effective compliance program. This is not the situation where you get a letter and say, we'd like to look at your compliance program. This is after you have self-disclosed. So you're already going to be in the soup, and you need to think about how your program's going to look, particularly when you go on a 3-year look back after you've self-disclosed. So the Yates Memo and Compliance Council, I think, are certainly a part of the top 5 compliance-related events of 2015. Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I hope you've enjoyed my 2-part episode on some of the top events, FCPA and compliance-related, from 2015. If you'd like more information, I hope you will contact me at tfox@tfoxlaw.com. Please remember, I'm having an upcoming FCPA Masterclass. If you're interested in all in best practices compliance program, this is the program for you. So give me a shout, and I can get you into the session, hopefully, if we're not oversubscribed or subscribed at this point. Also, if you could go to iTunes and rate this podcast, I would greatly appreciate it. It will help us with our numbers moving forward. This is Tom Fox. I'd like to thank you very much for listening to this and look forward to visiting with you again.